Waninaka ni tampag. Skata squamson. No to is Neesu Wushuwunoag to Federation, to Aboriginal Nations, to America. And I do hope that this message finds you well. It's been a while since I did the last video. I've had a lot going on. Very positive stuff. But as always, through the Federation, we always like to touch base every once in a while. Particularly when we see topics of discussion that could be pertinent or beneficial to individuals, nations, whatever the case may be, and just understanding a little bit better the role of indigenous folks who are aboriginal to these Americas, their role in kind of addressing the colonization that's going on, and of course that comes with understanding how it has been into play and how it is impacting us. So we're very blessed to be here this evening to share some thoughts with you. And tonight, I wanted to touch on a matter that's been pertinent, I would say, over the past couple weeks. It's popped up, but even before that, and it's something that floats around, and it's something that we hear a lot of people say, and we just want to make sure that people are really understanding what it is that they're saying when they say it. And we're talking about treaty rights and rights to treaties and which treaty rights apply to you and all of this understanding. Because at least from just listening and different conversations with different people, there might be a little bit of a misunderstanding out there in terms of how treaties apply to indigenous folks. And just want to clear that up a bit if we can. So I'm just going to touch on 5 points, and this is going to be very high level stuff. There are people who make careers out of understanding and developing and deciphering treaties. I personally have had the opportunity to be involved in the writing of two. One that we're still working on and one that we were able to sign with the Sovereign Kingdom of Atui last July. It was two of them actually, peace and friendship and health and wellness. So I was involved in constructing a very general language though, but people make careers out of this. So I'm not going to be able to go super in depth. I'm just going to try to give a very high level understanding, and my suggestion to everyone out there who comes across this and finds this of interest is to do more research on your own. But just 5 points to keep in mind when we're talking about treaties and how they impact the rights or the livelihoods of indigenous folks in their land. So first point that I want to bring out, and this is very key, and it's the basis so that you have a general understanding of what we're talking about when we're talking about treaties, and that's that they're contracts, right? They're agreements, because that's pretty much what a contract is. Two or more parties agreeing to certain terms or standards. And in particular, when we're talking treaties, mainly we're talking that they're commercial agreements. They're dealing with rights to utilize lands, resources, who owns the resources, who's supposed to receive what for use of the resources. So treaties are contracts between parties, and that's so key to understand, right? And I'm going to get into that a little bit later in a moment, but just remember that they're contracts. So when you have a contract, right, there's specific terminology in that contract. There may be guidelines or boundaries on what can or cannot be done. There might be a sunset clause, or when that contract runs out. Whatever the case may be, contracts are agreements between parties. So, and that's what treaties are, agreements between parties. And we're going to get into who those parties are in a moment. But just keep that in mind first and foremost, that treaties are contracts, and they're forms of commercial contracts because they're dealing with like land resources and all of those sorts of things that really come down to commerce, because it's all about commerce when you're dealing in international law. It's all about the language of money and how money exchanges and all of that sort of stuff. So treaties are contracts and commercial contracts of sorts because they deal of the matters that they deal with, rights to lands and things of that nature. So that's the first point. Second point, treaties are nation to nation. So nations form treaties with each other. So treaties are contracts that are specific between nations. Now, when you hear that, right, that should do away with any conversation from anyone about Indian tribes not being nations. Because when you look in pre-colonial, pre-US, and this is what's so important, and this is why if you watched our previous videos about tips on how to research and all that, we tell you check pre-US, colonial period. Because during the colonial period, before the US was even thought of, the European colonies were signing treaties with the Indian nations that were here. In the Northeast, there were treaties with the Poconokeets, treaties with the Narragansetts, treaties with the Lenape, treaties with the Pequots, with the Mohegans. They had to deal with each tribal nation as a separate nation. So when you hear anyone saying that Indian tribes aren't nations, you should just be able to wipe that right away. It's not that Indian tribes aren't nations, it's that certain steps have been taken to pull indigenous folks out of their ability to, what's the word I'm looking for? Enforce the treaties that they have. But it has nothing to do with Indian tribes not being nations, if they're in their proper status. So that's the second thing. Treaties are between nations to nations. So when the British Crown was signing treaties with the Narragansett and the Mohegans after the Pequot Wars, when the U.S. is signing treaties with nations as they move west, those are nation-to-nation agreements. Those are nation-to-nation agreements which should tell you the status of the tribes when they were engaging with Europeans initially. It was a nation-to-nation relationship. And the Europeans looked at the chiefs here as their equivalent of kings. This is why when you look at the King Philip's War, he's called King Philip. His real name was Po Metacom. Metacom being the type name, and Po telling where he's from Poconoket. So Po Metacom. But his title, his father's title was Massasoit. The English, however, trying to kind of equate what was going on with the indigenous folks to what they understood, started looking at all of the chiefs as kings and started to refer to them as such. But once again, the king is the king of what? A kingdom, nation, right? So treaties of nation to nation. And that should do away with that whole conversation around Indian tribes not being nations, because how on earth were the Europeans agreeing to sign treaties with Indian tribes if they're not nations? So first, treaties are contracts, commercial of source because of the things that they deal with. Secondly, they're nation-to-nation contracts. That's what treaties are. Thirdly, and this is, I hope, what clears up a lot of the misunderstanding out there, they're specific, right? So when you have a contract with someone, that contract pertains to the parties that are part of that contract, right? If I sign a treaty with Joe Schmo, then that treaty is between myself and Joe Schmo, and whatever the language that we apply in there. So let's put this to the Indian tribes, right? The Narragansetts signed treaties with the English crown. The Narragansetts are party to those treaties, and so are the English crown. That then means that in order to enforce or apply that treaty, you have to be a Narragansett or the English crown. You cannot be a Poconoket and come and enforce a Narragansett treaty because you're both indigenous. You cannot be a Lenape and come and enforce a Narragansett treaty because you're both copper colored. And this is why we are consistently saying you cannot do that generic stuff. There are no treaties with indigenous folks. There are no treaties with copper-colored aborigines. There are no treaties with autochthonous people. There are treaties with nations. Narragansetts, Poconokets, Massachusetts, Nipmucks, whatever the nation is, if it's a treaty, then it's a treaty between a certain power and a certain power. And if you are not party to those treaties, you cannot enforce those rights. You cannot tell the U.S. government, oh, you have to acknowledge the treaties. They're going to say, which treaties? And then that's going to lead to which nation you're a part of. And if you don't know which nation you're a part of, if you are refusing to do your genealogy, if you're refusing to put in the time and the effort, then you don't have any treaty rights to apply. None of those treaties apply to you. There are no generic treaties with indigenous copper-colored autochthonous people. They don't exist. You cannot enforce a treaty right unless you're invoking that you're party to that treaty by identifying what nation you are a part of, right? So now let's also look at this situation where you hear a lot of individuals talk about the Treaty of Peace and Friendship between the U.S. and Morocco, right? That there, they're trying to say, oh, that applies to all Moors. No, that's going to apply to Moroccan Moors because it was a treaty between the U.S. and Morocco. So Moroccan Moors, which means if you're a Moor who doesn't have connections to Morocco or who is not acknowledged or recognized by Morocco, that treaty's not going to apply to you. Treaties are specific to the parties that are mentioned in them. And if Morocco has a treaty with the U.S., and if Morocco was saying you can't treat certain people a certain way, then those are the people that are party to or under the jurisdiction of Morocco. If you're not under that jurisdiction, how are you invoking that treaty? If you're not under the jurisdiction of the Narragansett, how are you invoking a Narragansett treaty? If you're not under the jurisdiction of whatever nation it is that's party to that treaty, there is no way for you to invoke that treaty. So once again, if you're looking to really secure your rights and protections as quote-unquote indigenous, autochthonous, copper-colored, whatever English colonial adjective or descriptor you want to use, because none of them are in our language, none of them are in your language, this is all colonial terminology, you need to be specific and show that you are party to the specific treaty. You cannot claim all treaties because you're an indigenous that's all just foolishness. And there's no contract on earth that would allow you to make yourself party to it if you're not written down as a party to it. If you're not acknowledged as a party, I cannot go and say, well, the people across the street, purchased the house, but I'm going to go use the house too because we're all in the same neighborhood together. No, I need to be party to that particular contract between those people and whoever they got the house from. Same thing with your treaty rights. You have to be party to them. They have to be specific to your nation. And once again, they're nation to nation. So you as an individual have no authority. It has to come from your nation. Your nation has to be the one to enforce treaty rights. And if you're not part of a nation, or if you're trying to do this band thing where everyone just gets together because we were all colonized, well, you're not going to get anywhere because what treaties are applying to you in a band? You're making up something new. So they're specific and you have to be party to them in order to enforce them. So one, treaties are contracts, primarily commercial because of land and resources and the things that they address. They're nation to nation too, which means that Indian tribes are nations because they were signing treaties with the colonial powers. 3, they're specific. You have to be party to them. So you can't just claim a treaty because it's an Indian treaty. It's an Indian treaty because they were dealing with this group of nations that they titled Indians. But your treaty needs to be specific to your people, detailing what the arrangements or the agreements were in that treaty. So 4, this is very interesting, one that you should be very well aware of. Treaties are the highest law of the land. They trump all of the domestic and municipal and all of that nonsense that's going on because they're between nations. Domestic and municipal and federal and all that are for citizens of a particular nation. So the U.S., if you're a citizen of the U.S., then you're subject to all the domestic stuff. But as soon as you're a citizen of or under the jurisdiction of a separate nation, international law comes into play. And in which case, they're not going to defer to federal, they're not going to defer to state, they're not going to defer to municipal, they're not going to defer to any of that. They're going to look at what the international relationships are. International, between nations. And those are going to be treaties. And if, they're going to look at what the language of the agreement between the nations are. So all of this federal stuff and all that, it's all going to be trumped by treaty law. And this is why, once again, you need to get back to who you are if you're trying to deal with U.S. colonization. Because if not, then you're subject to whatever the U.S. is agreeing with. Then you need to get busy voting, and you need to get civically engaged, and you need to be engaging with your political leadership. Because if you're a U.S. citizen, that's what it's going to take to protect your rights and make change happen. If you are moving in your proper capacity, if you repatriated to your proper nation, if your nation is established correctly, you're getting into international relationships and treaty relationships. So, 4, treaties are the highest law of the land. Nothing's trumping them lower like federal or anything like that. It's international law between nations. So I'm coming to my last point. Let me just recap quickly so you understand where we're at so far. First of all, we're talking about treaties, right? And the first thing that I mentioned, that treaties are contracts. Primarily commercial contracts because they're dealing with land and resources and who has rights to them and all that. So they're contracts. Secondly, treaties are nation to nation. They're between nations. They're a specific type of contract that's between nations. And this should do away with any of the foolish talk about whether Indian tribes are actually nations or not. Third, they're specific. You need to be party to them in order to enforce them. So once again, you cannot be claiming to be an autochthonous or indigenous aboriginal copper-colored person who was misclassified and then talk about treaty rights. There are no treaties with any of that as the party to it. There are treaties with nations, and if you're a member of a nation, then you could potentially argue, being backed up by your nation, that you are protected by the language in this treaty as you're a citizen and under the jurisdiction of your nation. And then fourthly, they're the highest law of the land. So they're trumping federal, they're trumping state, they're trumping domestic, all of those terms, municipal, all of those things that are lower than international law, treaties are trumping all of them. So what's the fifth one, right? And this is the most exciting part. The treaties are still in play. The treaties are still in play. And we should see this, if anyone's been following the new Associate Justice to the Supreme Court, Neil Gorsuch. He's a staunch conservative, but he just voted in 2 cases this year to back up treaty rights for Indians. The most recent being Herrera versus Wyoming, where I think they were trying to say a particular Indian couldn't hunt off-season, and he enforced treaty rights, and the treaty said that they could. And the other being Washington State Department of Licensing versus Cougar Den, where once again the treaty rights stood above. And if you look at the Herrera versus Wyoming case, it was very, very clear that at the time that the treaties were signed, there was no intention on the part of the U.S., no language in there that ever mentioned that they would be, sunsetted once states were incorporated. And nor could it be shown that the tribes had any intention or understanding that that's what the case would be. So since it's a contract, right, they're looking at the intent of the contract when it was signed, and no, that's not the case. Now, how is it then that so many tribes are getting their treaty rights stepped on? Well, it's going to be 2 ways. First, they're either in a federally recognized relationship with the U.S., in which case they are becoming domestic dependents, and in which case they have no rights to enforce treaty rights because they're domestic dependents. You've agreed to a relationship that puts you in an inferior position, in which case, especially if your lands are put into federal trust, those are federal lands. So what are you talking about if you gave your lands over to federal trust for money and all that sort of stuff? So that's the first way. And the second one, and we did a video on this before, so you should definitely go check that out, was about the Indian Citizenship Act of 1924, the Snyder Act. And why is that important? Well, because by law, citizens cannot claim treaty rights against their own nation. I, as a tribal citizen of Mashipog, cannot claim treaty rights against Mashipog. I'm subject to the jurisdiction of Mashipog. I'm party to treaties that Mashipog is party to, but I cannot, as an individual, enforce treaty rights against my own nation. And this is the problem that African Americans, black people, colored folks, Native Americans, all of these colonial terminologies that denote a inferior status to the U.S. or jurisdiction from the U.S. over you run into. You don't have treaty rights against the U.S. You're subject to whatever the federal, domestic, state, municipal policies and regulations are. Plain and simple. Citizens cannot invoke treaty rights against their own nations. So this is why, if you pay attention, the Indian Citizenship Act came out where they made a commercial claim against all Indians saying that they're all citizens, right? They say, oh, well, we're giving them citizenship because we want, it's been a long time and we need to do the right thing. No, you're giving them citizenship so that they can't argue treaty rights against you anymore. So that you don't have to worry about dealing with them as separate nations. So you can get rid of the whole Indians not taxed thing. All of that. If these people become citizens, all of that goes away because it's all domestic now. It's all in-house. And here's the other element, right? Since it's all in-house, no other nation has the right to come in and tell the U.S. what to do with its citizens. Because if that's the case, then the U.S. could go into other places and tell them what to do with their citizens. And who's going to give the U.S. leeway to do that legally? No one's going to do that. So it's not that there's anything wrong with the treaties. It's that through deception, through fraud, through all of these different things, commercial claims that are unrebutted, the U.S. has put most indigenous folks that are aboriginal to these lands in an inferior jurisdiction to the U.S. so that they cannot enforce their treaty rights. However, the treaty rights are still in play. And this is why, once again, FANA encourages everyone, trace back to who you are before European colonization started. Organize your family, because that's your tribe, that's your clan. Get all of the documentation together and move appropriately so that you're in a position, they call it standing, so that you have standing to actually enforce your treaty rights. If you don't have standing, it doesn't matter what you're arguing. You could be 200% right on a scale of 1 to 100, and it will not matter because you do not have the standing. If you're still classified as a U.S. citizen, you don't have any right to argue about treaty rights. You're a U.S. citizen. You need to go talk to your political leadership about changing the rules that they have governing you, because you're most certainly not bringing any international law in, and rightfully so, by law. By law. And this is by the law that everyone follows. Remember, no one's going to come in here and tell the U.S. what to do with its own citizens, because that opens up the door and gateway for the U.S. to come in and tell you what to do with your citizens. And who's going to do that? So it's not about people not wanting to help us. It's not about people not, caring. It's about what the law is. And as we keep saying, the issue is not the law. The issue is our lack of understanding of it. Once you understand how to maneuver and navigate through the space, the same laws that have been being used to oppress you can now be used to protect you and serve you. And this is what we've been seeing through FANA. So 5, despite what they tell you, the treaties are still in place if you have the proper standing to enforce them. But you have to have the standing. And if you have the standing, all of those things are in play. The law is the law, and you can enforce it just like anyone else can. So, let's just quickly recap. Looking at 5 elements, just 5 elements to keep in mind when you're thinking about treaties. With Indian nations, first, their contracts, commercial in nature, because of the things that they deal with. They're nation to nation. And this should, do away with any questions about whether Indian tribes are nations. Absolutely, they're nations by international law when they're in their proper status. They're specific, so you have to be party to them. So once again, you can't be a copper-colored, aboriginal, autochthonous, indigenous, whatever, Niji, and claim treaty rights. There's no treaty with the autochthonous, indigenous, aboriginal. There's no treaty with any party named that. There's treaties with Nahigantits, Lenapes, Poconoquets, who else? Tuscaroras. There's all of these treaties with these different nations, but none with colonial terminology for Aborigines or indigenous folks. None whatsoever. You're not. Show me the treaty that's between the U.S. and the autochthonous Aborigines. Show with that language in it, where the autochthonous Aborigines and the U.S. signed on a treaty. It doesn't exist. Those are descriptors and adjectives. They're all in English. They're not who we actually are. It's just terms to describe your status in a U.S. English-speaking colonial system. So you have to be specific and party to it. Fourthly, treaties are the highest law of the land. They trump all the federal and domestic stuff, despite what they want to tell you. And the only reason they're telling you that is because most of us are not in a position to enforce them. And then 5th, they're still in play. And we've just seen this with Herrera versus Wyoming and Washington State Department of Licensing versus Cougar Den. But also when you understand that they're still in play, then you start to understand better why they implemented systems like federal recognition and the Indian Citizenship Act of 1924. So hope that informed y'all a little bit out there. Maybe answer some questions that y'all had in terms of what's going on with treaties, why Indians don't seem to be able to enforce them even though they're written down and they're right there. And once again, it all comes down to standing. If you're not operating in the proper capacity, and the strategy that FANA endorses and has implemented ourselves is operating through private foreign American Aborigine tribal trusts. If you're not operating in that capacity, you're not going to have standing to enforce them. And then for you, the treaty rights are gone. But they're not gone. They're fully intact. We've just been removed from our proper standing to be able to enforce them. So hoping that is a benefit to y'all out there as y'all are making your moves. We're seeing a lot of positive stuff out there. Many thanks to all of those who have been sharing footage and videos. I'm not sure what's going on, but just looked at the Indian slavery discussion we did at Brown University, and it jumped like doubles up to like 100, I don't know, over 100,000 views, 120,000 views or something crazy. So I'm not sure what's going on, but there seems to be a lot more interest in that sort of background and experience because it was so key, especially here in the Northeast and going down into the Southeast. So many thanks to all of those katapatush, for everyone out there who's checking those out and sharing that information. And yeah, I hope this is helpful. And as usual, you know, we hope that you all are making good strides on your own path to self-discovery because it's so key and it's so important. This is a basic element that the entire family of mankind, humanity, whatever term you want to use, understands. We've just had that sensibility taken away from us because of colonization, but slowly and surely we're getting it back, and that being you have to know who you are. Honor your mother and your father. Know thyself. All of these things are basic principles that are known throughout the world, and we cannot be looking for anyone to feel bad for us or have pity on us if we haven't even grasped and embraced that element. That's a basic, knowing who you are. So hoping once again that this is a benefit to you all. And as always, we say peace kanash because there is no goodbye in our language. Peace kanash. Definitely hope to be seeing you all soon. I hope.